Thank you, everyone, and good afternoon. My name is Jennifer Needle Suarez, and on behalf of the University of Minnesota Center for Bioethics, I would like to welcome everyone to our Ethics Grand Round series. Today, we are happy to host Dr. Meredithe McNamara, who will be talking about oaths and expertise. I will quickly go through some logistics before we introduce Dr. McNamara for our participants. As a disclaimer, the views expressed during today's talk reflect Dr. McNamara's own and not those of the Center for Bioethics. You can read the disclaimer. We will be using the Q&A function for this question session at the end. Please ask your questions there. And if you're having any technical difficulties, use that function as well, and the center staff will respond. This talk today will be recorded and posted on our center website. Captions are enabled, and there are 3 ways to access the evaluation. In the web browser, it will pop up, as well as in the presentation details document that's available in the chat. You will see a link to access the evaluation, and you'll receive one after the event by email. If you are looking for CEU credit, there is a form in the presentations documents detail, as well as for IPE credit for biomedical engineering students. There will be a quiz in your Canvas page, and you are required to attend 75% of the webinar to receive credit. We would like to thank our large group of co-sponsors, which I will leave here for you all to read. And without further ado, I am very pleased to welcome Dr. Meredithe McNamara, who is an assistant professor of pediatrics at the Yale School of Medicine. Dr. McNamara is a board-certified pediatrician and adolescent medicine specialist. In addition to her work as a practicing clinician, she conducts research on scientific disinformation and health policy. And as the co-director of the Integrity Project, her research and writing is operationalized in policy processes via testimony, public comments, and litigation. Please join me in welcoming Dr. McNamara to our Ethics Grand Rounds today to discuss oaths and expertise.
Thank you so much, Dr. Needle Suarez. It's a pleasure to be joining you all today. I know I've already gotten a bit of an introduction. I will just reiterate that I am an adolescent medicine physician. It's a subspecialty within pediatrics. And I also conduct research on scientific integrity and health policy that impacts adolescents and young adults. The area where I've been the most active is in the identification and debunking of disinformation used in policy processes to justify legal interference into youth gender care. This is an area where I've identified well-developed and particularly virulent strategies that warp evidence-based medicine and bioethical principles while supplanting medical decision-making and informed consent. It has become my professional view that acceptability of legal incursion into transgender healthcare has and will continue to soften our collective tolerance for incursion elsewhere. So I think we need new ways of thinking about the policies that govern medical practice. I have come to view health policies as medical interventions themselves that unfold quite differently from how clinicians are trained to provide and how patients expect to receive healthcare. So I've titled this talk, Oaths and Expertise, the Bioethical Consequences of Health Policy as Medical Decision Making, so that we can explore the space where policy and healthcare meet. Oaths represent the responsibilities that parties shaping policy can either claim or shirk. And the expertise of oath takers can shape the degree to which policies help or harm. Now, in an effort to provide you all with something visually engaging, I am going to include the works of the abstract expressionist artist, Helen Frankenthaler, on my slides. I know this is a little off the wall, But her genre of painting arose in the aftermath of the global trauma of World War II in response to existential anxiety and disillusionment with traditional styles of thinking. Um, Her work is particularly meaningful to me because of its bold expressions of softness in a time when her male peers like Pollock and de Kooning embraced harsh colors and lines that convey intense emotion. Her color palettes and the drip technique that she pioneered were criticized for being too beautiful or romantic, which was a double standard that her male peers were never held to. So this reminds me of the double standard that some types of medicine are held to, and the faulty logic used in policy spaces to decide which types of care should be scrutinized and which should be left alone. Frankenthaler's work survived double standards. I believe that the double standards that imperil many aspects of medical care will be survived as well. Her paintings are now taken seriously for what they are, singular, tangible, and infinitely expansive, just like the human needs that clinicians and scientists tend to, like the needs for food or shelter, or affirmation or health, needs that are oversimplified to the point of neglect in policy, but defiantly lifted up in social discourse. So I hope that when you see her paintings during this talk, you will see a form of art that doesn't have answers, but models the processing of loss, of ambiguity and complexity, just as we do in medicine and science, and especially today. You'll see images that are environments that welcome you in, that contain nuances that embody the nuances of the human condition that we embrace in medical practice. I find that expansive and creative thinking is a way to build resilience in today's climate, and I just wanted to model that a bit for you all today. So we have four objectives. We will define health policy and the social contract, sorry, and explore what the concept of bioethically sound health policy is. We'll describe past and present relationships between policy and healthcare, grounded in historical examples, contextualize emerging trends in health policy and apply bioethical principles to their impacts, and build a shared understanding of effective engagement in health policy development, hopefully through discussion. Just two disclosures, I have received expert witness payments through work with GLAAD and Human Rights Campaign to LGBTQ legal organizations. And I'd like to start, I feel like I have started, but I will start again with a reflexivity statement where I shape our terms of engagement by answering the question, why me and why this topic? This analysis emerges from my perceived duty of care from the science of adolescent development and my perspective on how policy can both protect and endanger young lives. So, what am I seeing in the exam room these days? I see the fear, the rage, and the grief from healthcare institutions preemptively enforcing executive policies that limit life-affirming care for transgender people. I see young people, my patients, their parents, legitimately afraid that their livelihoods will be upended by immigration policies. It was not that long ago that an 18-year-old was arrested and sent to Louisiana without due process and picked up on the grounds of the high school that many of my patients attend. And then there's also this kind of thick air in the exam room these days when we're realizing one patient encounter at a time that health coverage opportunities are dissipating due to impending federal legislation via the One Big Beautiful Bill Act. The visits that I have with a refugee or an asylee or a young adult on Medicaid for complex problems like eating disorders, substance use, chronic illnesses, that each one of those visits could be our last. So I'm here as a moral witness with proximity to harm. I think anybody in healthcare or any sort of social engagement field is a moral witness these days. I believe that the concept of witnessing is active. It's about seeing and speaking. It's about being descriptive of problems and prescriptive of potential solutions. And while I can't explore this topic in the proper depth that it deserves, I can hopefully lend some language and generate some thought and interest so that everybody can continue this conversation afterwards. Um, so I want to just begin with a thought experiment where we explore a particular quandary that I see in health policy. So unfortunately, oh, here we go. Yeah. So imagine a scenario in which new patients are seen for a particular chief complaint in a specialized clinic. In the first scenario, everyone is given the same diagnosis and prescribed the same plan of care. In the second scenario, there's variability. Perhaps one person is given a diagnosis and the plan is just to keep an eye on things. Um, Perhaps others are given more specific diagnoses and plans that depend on their values, their preferences, their resources. And another is given a straightforward diagnosis, but maybe like just elects to wait with a plan of moving forward at some time in the future when they feel more prepared. So my question is, which scenario would you want to refer one of your patients into, or would you want one of your loved ones to receive care within? Which scenario one or scenario two, is most likely to be bioethically informed? Well, let's just apply the basic tests. A basic bioethical framework to the simplistic scenario where everybody is viewed as the same and offered the same care lends a little bit of insight into the real systems that people are navigating today. So, through the lens of autonomy, a standardized one-size-fits-all treatment plan does not respect autonomy. Every patient has unique goals, values, and preferences that are just as nuanced and different, like the painting in the background of this slide. Um, and all of those nuances should guide clinical decision making. If we're not holding space for those nuances, if they have no place in the exam room, then informed consent isn't really occurring. And regarding beneficence and non-maleficence, uniform treatment without personalization or modification is likely to impose harm and cheat our patients of specific benefits. Regarding justice, ethical healthcare should distribute benefits and burdens fairly. Applying identical plans disregards people's the social, biological, and structural inequities that people face that affect health outcomes, particularly for marginalized groups. A fair system and a fair kind of algorithm of care recognizes and compensates for those differences rather than pretending that they don't exist. So in this thought experiment, the bearer of responsibility is important to identify, right? The person or the entity that holds specialized knowledge and institutional power and is exerting that power over and beyond every other party who seeks to be influential is really the one that has to be identified. Now, typically, an audience like ours would consider that the healthcare provider is the one making decisions, and perhaps even the institution that regulates that provider's time and validates their credentials. But this is too simple of a perspective in today's world. It obscures the true locus of power and the influence in healthcare relationships. So we can't assign responsibility to any entity without understanding the true power structure. What if in scenario one, there are policies that limit professional speech and penalize the provider for discussing certain diagnoses? What if there are policies that criminalize the standard of care? The reality is that scenario one is unfolding in more clinical domains as we see policy incursion into gender care, reproductive health, infectious disease prevention via mask mandates or vaccines, medication safety, the public funding of healthcare, and many others. We have diverse cohorts of patients seeking care in the domain of restrictive policies that are being assigned plans of care shaped first and perhaps only by policy rather than medical decision making and basic bioethical principles. If those policies supplant the ability of the provider and the patient to partner, then we may consider those policies as medical interventions that can be held to bioethical principles that they fall short of. All right, so now let's shift gears, ground ourselves in some shared concepts. I think I've been talking about policy a lot, but I'd like to just define it. Um, I consider policy to be the laws, regulatory decisions, litigation outcomes, and governmental practices that impact people's health and well-being. In this sense, I view a judge's written opinion in a lawsuit challenging a preventative care, no cost sharing mandate to be health policy, such as the judicial opinion in the Braidwood versus Becerra case, which opined on USPSTF preventative care mandates. And it is health policy, especially because it sets a precedent for how future laws or policies that impact preventative care mandates are written or interpreted. Similarly, I would also view a governmental practice of, say, family separation on the basis of immigration status to be health policy because it shapes the trajectory of children's lives by imposing an adverse childhood experience that impacts cognitive function. And the lawsuits that challenge that practice or seek restitution for the harms of that practice also constitute health policy because they influence the ways in which tangential practices might unfold in the future. So we're going to have a really expansive view of what health policy is. And I think that's, in service of the topic and also makes things harder. So we should also understand the formal and informal oaths that shape governing structures, the populace, and healthcare's interactions. The social contract, I always say construct, I mean to say contract. The social contract is a framework developed by Jean-Jacques Rousseau during the Enlightenment, which was a period of profound political reform and revolution in Europe in the latter half of the 18th century. Like, we think we have it crazy now. I think they had it a lot crazier, actually. Rousseau sought to describe a healthy implicit agreement between a people and a governing power, agreements that did not previously exist, where some freedoms have to be surrendered in exchange for protection of non-surrendered freedoms and maintenance of social order. Now, I think a fun practice, especially as a pediatrician, when you're dealing with heavy and large concepts, to think about how a kid would see it. So I took this picture in a fifth grade classroom of kids describing a social contract that they held with their school, their teacher, and their peers. And you see words here like honest, fair, listen, nice, overwhelmingly positive, which really should be what a social construct is about. Something that is constructive and protective. Um, Also, all these students sign their name. The social contract should be about transparency and accountability. And what does this actually have to do with health and health policy? Well, today and for a long time, members of our communities, patients that clinicians serve, are receiving care in an environment in which they have ceded some rights to the state in exchange for an enhanced sense of well-being. All of these relationships and expressions of the social contract are playing out um, around and above an oath that clinicians and clinician scientists have taken, called the Hippocratic Oath, to do no harm, to protect privacy and share knowledge, and practice with conscience and dignity. Here's a little scroll of part of it from thousands of years ago when it was first described. So I bring up these oaths because they are all kind of occurring at the same time with expectations, with implicit and explicit agreements, idealized and realistic expressions. But importantly, this Hippocratic oath is not one that really exists in the social contract, and yet it's one that people who bear the most proximal responsibility are expected to uphold. So let's do a little kind of compare and contrasting of the oaths that clinicians and policymakers make. The primary duty of a clinician is to patient well-being, but policymakers swear an oath to uphold government doctrine and represent majority interests. These are different things. Regarding accountability, providers are held accountable via the professional imperative to avoid harm and serve the individual. But policymakers have their accountability kind of spread diffusely across the population. Providers relate to the truth and reality very concretely. There are expectations that we say what's true in professional work, but policymakers don't actually have a parallel binding obligation. Healthcare providers must care for all. Their responsibility is to every single person who seeks them out for care, and even maybe beyond the individual that they care for in an exam room due to responsibilities regarding public health. But policymakers are really only functionally responsible to a majority, and that majority may shift over time, but it's certainly not this totality that healthcare providers experience. And then regarding professional sanctioning in healthcare, the sanctioning that happens around misconduct or harm can be quite severe. It can be life-altering. But policymakers, we're really talking about the professional sanctioning of votes, of loss of office, and all of that is circumventable. Um, it is important to note that just on its own, in the bubble that it exists within, healthcare does regulate itself. There are many examples of how the care that we provide is governed by mores and expectations around the scientific process, leading to guideline development that's carefully honed and expected to improve over time. So here is a snapshot of the National Academy of Medicine's guidelines we can trust. It's guidelines on how to produce guidelines. This is doctrine, in our bubble, and we use hierarchies of evidence to iteratively discuss the types of care that we should provide. Bioethical principles and professional oaths are other concepts that provide doctrine for describing how we use our expertise, how we take care of people. And it's not the case that anybody can just show up and do the work of healthcare, right? We have really lengthy, extensive accreditation and boards requirements. Our institutions can only hand out diplomas to people to offer this to do this work if they adhere to strict requirements. And there are times where we kind of like update the oaths that we operate within. That's what the Declaration of Geneva is. It's kind of like a modern day Hippocratic oath. And I specifically pulled out this kind of like original snapshot of it pertaining to care of the child. So healthcare has always sought to regulate itself for common good and has done so in many ways. Traditional ways in which the state, meaning government or policy, involves itself in healthcare can be quite large and quite small, right? So tort and liability laws are kind of always looming in the background of clinical care and perhaps edging us towards different patterns of care to ideally minimize harm. Licensing requirements can come from government to decide how and who practice should unfold in various states. There are healthcare coverage mandates that come from policy that tell doctors what care, they feasibly can and cannot provide. There are preventative care coverage mandates that I've alluded to that come from government. There are governmental bodies that make recommendations that are taken quite seriously. And then there's environmental and food regulations that shape the climate of health or illness that our patients live within. And none of these are things that the healthcare system can write, enforce, and use to regulate themselves. but these are processes that we can play a role in and that play a huge role in shaping people's well-being. Now, where the population benefits are most pronounced happen when there is actual partnership between clinicians and policymakers and scientists. Things like the Ryan White Care Act, the Vaccines for Children program of 93, the Mental Health Parity Act. All of these were areas where clinicians and scientists acted as moral witnesses, armed with data, and framed the issue around public health and public good, leaving moral judgments about sex, addiction, poverty, etc., just behind from processes. The major distinction, though, between how healthcare regulates itself and how the state regulates healthcare is that the consequence structure tends to be much harsher and even favoring punishment when the state begins to intervene. There are consequences for not adhering to Medicaid participation requirements, consequences for offering care that's criminally banned. These are things that we cannot do to regulate ourselves because that's simply not how we operate. Now, at this point, I think I've made the case, or I'm trying to make the case at least, for all of the good work that healthcare providers and scientists do within our bubble to regulate ourselves. But this concept of lapsed internal regulation is quite real. There are several harmful practices that have been once thought of as standard. It was once a thing to institutionalize people with physical or developmental disabilities. Lobotomies used to be the treatment of choice with really no external regulation and very little brake pedal within medical practice itself saying that this is harmful and these are wrong. Not that long ago, opioids were vastly overprescribed without any sort of internal regulation, without really any sort of data, without guidelines supporting their use. Uh, Disconceptions, I say dis because these weren't accidental, but intentionally harmful disconceptions about race, ethnicity, pain, physiology, really went unquestioned and were unevidenced. And then I think, just to crystallize on reproductive health care, um, our internal regulation, our oath structure really failed when it came to the oral contraceptive pill trials in Puerto Rico in the 1960s, or La Operación when 160,000 Puerto Rican women were subjected to tubal ligations without consent. Enthusiastic recommendations for thalidomide in people who were pregnant, or high dose hormone replacement therapy for postmenopausal women, all led to predictable harm. And again, our internal regulation, our data structure, our guideline structure did not help. Even within the past 10 years or so, we have inmates subjected to mandated contraception, tubal ligation without consent, just beginning to share their stories within the past couple of years via lawsuits. So I just want to emphasize that I am not of the mind that the health system gets this right consistently and doesn't need external policy to regulate us. But what is notable is that there are very few health policies that arose from each one of these examples to ban or outlaw or interfere in practice. And that may be something that comes up in our discussion. It also just takes, it's important to acknowledge the courts. The courts are another element of health policy development. And courts have this really unique opportunity to opine on legislative findings of fact. But unfortunately, they don't seem to be able to do so with consistency, accuracy, or precision. So when policymakers generate health policy, they may not, but they may undertake an effort to identify scientific facts and incorporate them into their policy. And when those policies are subjected to judicial review via litigation, plaintiffs and defendants will gather, a ton of evidence to try to prove their case in court, and the court tends to defer to the state. So if anybody ever has a chance and wants to read kind of a longish paper, the QR code here will lead you to a really wonderful paper by a law professor named Jesse Hill. It's called The Constitutional Right to Make Medical Treatment Decisions, A Tale of Two Doctrines. And what she asserts is that legislators are really ill-suited to the task of scientific fact-finding, and judges are not really suited to being medical decision makers, but they should weigh the scientific evidence before them. Um, and she describes the many ways in which they struggle to do so. So her paper outlines the public health world, the bodily autonomy world. Not that these issues are completely separate, not that mandatory vaccination isn't bodily autonomy or isn't public health, but the framing in litigation is kind of how each one of these cases unfolded. So the asterisk here kind of represents or signals the fact that when SCOTUS opined in this case, they deferred to legislative fact-finding. And it is much more common that no matter what the truth actually is or what evidence is presented to the contrary, that courts tend to side with how the states have gone through their fact-finding. So mandatory vaccination regarding smallpox, even though additional evidence was provided that potentially this vaccine could have been dangerous to the person who wanted to refuse it, uh, the court just deferred to the state's assertion that vaccination was completely safe. The court has also completely deferred to the state on the unilateral complete toxicity claims about alcohol use. The court has deferred to the state about the complete absence of any medicinal benefit in cannabis for people with cancer or chronic illness. The court has also deferred to the state on the lack of medical necessity for end-of-life treatment, which is something that the plaintiffs provided a very nuanced scientific argument about. And the court has struck down legislative findings of fact in contraception for married persons and some of the earlier abortion cases. But it is much more common that the court will take a legislative scientific fact determination as gospel and not be able to weigh counterbalancing scientific facts. So now that we've explored older topics and examples, I think we'll move on to some of the quandaries that we face today. The fact of the matter is, and I see this from my vantage point, I hope most people agree, is that health policy is becoming more pervasive, meaning impacting health and well-being, and more invasive, meaning that it is determining and steering the care that people can and cannot have. What I would say is that, the policies that we're seeing now, like family separation, interference in family structure based on presupposed immigration status, child endangerment terminology, and bans on youth gender care, fetal personhood laws, the remanding of LGBTQ foster youth into non-accepting homes. All of these are policies within recent years that strike very deeply and painfully into people's private lives and into the domains of their life that they may seek healthcare for. Let's go over a couple more recent examples. So I am going to just kind of spotlight women and children's health. All of these are policies that pertain to the care that my patients need. So the Tennessee Medical Ethics Defense Act of 2025 allows conscientious objection for obstetric providers to refuse care to unmarried women. Bans and limitations on youth gender care. I've mentioned there are 27 states that now ban this care. There is a cascade of federal policies attacking this care either via reimbursement or seeking to intimidate providers and institutions that house this care. But it also simultaneously codifies non-therapeutic procedures on those with intersex conditions. Fetal personhood laws that frame maternal substance use as child endangerment. Uh, this, I think, snuck under the radar and has not received a great deal of attention, but adolescent confidentiality for reproductive and sexual health via Title X funded care is no longer possible in the state of Texas in a case that was decided in 2024 called Deanda versus Becerra. And I've alluded to some of these other ones, but I think we're really just seeing more and more that we're not alone in clinical situations with our patients. There's more muck to wade through, and there's more holding us back from being able to offer best practice healthcare. So when we compare what I would consider to be a traditional or a normative relationship between the state, healthcare providers, and patients, we see how pervasive and invasive policies cause profound changes. Typically, we don't feel the role of the state in the exam room, and we don't sense its presence in how we talk to our patients. Now, there are many ways in which, sorry, I lost my place here. There should be, bidirectional communication between providers and patients, but what ends up happening in kind of the invasive, pervasive climate is that providers might be unlikely to bring up a certain type of care if they know it's not going to be covered by a recent policy impacting insurance coverage, or if a certain type of care has been recently criminalized, or if there's confusion on whether or not they're even able to offer the care. So the relationship between these three parties becomes unbalanced, and the state kind of begins to play a much more authoritative role. One of the harms of this change in the state provider-patient relationship is an introduction of a newer type of uncertainty. Not the uncertainty that we discuss in informed consent when we counsel patients on the knowns and unknowns of treatment, but uncertainty in the sense that we don't know the contours of medical practice rules that we must abide by to avoid punishment of the state. There are so many examples of this in recent years. There is the fact that, for instance, 1.4 million lawfully present immigrants are likely to lose health benefits in the coming months due to the One Big Beautiful Bill Act. And what that looks like in the exam room, where that becomes worst practice, is trying to offer medical care when you know none of it will be paid for, when you know every test that you're going to order, or everything that you would like to do for your patient will become a financial burden. You're not thinking about best practice, and you're certainly not the one actually practicing medicine. If anybody has ever had to take care of a patient who doesn't have insurance and needs care, and you're trying to think, what is the least financially harmful thing I can do to this patient today? That's what I'm talking about, but on a population scale, the likes of which we have not seen. There's also the quandary of what happens to transgender young people who are receiving best practice medical care for gender incongruence, but then are suddenly told that they can no longer receive that care in their medical home, either because the institution has capitulated to executive policies, or because the state themselves forbids providers from practicing it. There are clinics that are ceasing practice kind of abruptly, and what providers are dealing with in the exam room is what is the rate at which I can cease offering this care that would provide the minimum amount of harm to my patient? because it is not the case that every patient that loses care in one particular setting is able to get it elsewhere. Um, and then there's one very specific example that I'd like to highlight that can be really hard to talk about. This is a young woman named Adriana Smith who died at the age of 30 within the past year. She received emergency care in her ninth week of pregnancy for a severe headache, and it wasn't recognized until it was too late that she had had intracerebral blood clots. After having had several strokes at home, being declared brain dead at a university hospital, her medical decision makers decided that they wanted her to be removed from life support, that they did not want, and I use life support loosely, but they did not want advanced measures like intubation or artificial nutrition to sustain a heart rate for an indeterminate period of time. However, the hospital that she was receiving care in was worried about compliance with the state's abortion law and felt that this decision that her medical decision makers wanted to make wasn't possible. So this is a terrible situation. It was a terrible situation, but the medical uncertainty is what I want to highlight about this. We do not know how to best take care of somebody in this physiologic state. We don't know how to maintain intubation and artificial nutrition practices in somebody who has experienced brain death for months and months and months on end. We don't know what that does to a fetus starting at the ninth week of life and onwards. And I think that, for the NICU team who received the admission of an 820-gram infant at 24 weeks to a mother who was slowly dying, there is no evidence on how to take care of this person. None of this feels ethical or evidence-based. And I think my contention that I want to leave everyone with today is that there's overlap. That these concepts of what is evidence-based and what is ethically sound really do belong together. And we have to live in a world where policy governs some aspects of the care that our patients receive, but that it should be fairly small. That the area of overlap where everything looks really clear, where we know what's evidence, we know what's bioethically sound is not something that we have to guess at. And I think that if we're going to talk about what an idealized framework would be, it would be policy that passes bioethical tests, that is sound and evidence-based, and policy that isn't going to need to be reconsidered or rewritten as these concepts changed over time. So I think ultimately what I'm arguing for, and this is not life-altering, earth-shattering, mind-blowing information, is that really the intersection point between evidence, ethics, and policy is really quite small. And it's that we focus on improving our internal systems of regulation so that they are as ethically sound as possible, so that we're not dealing with those horrific examples of lapsed regulation in the past, and that we're centering our patients and really inviting their commentary every step of the way. I'm just at about the 15-minute mark, so I'm going to stop there and see if we can have a little bit of discussion now.
Fantastic. Thank you so much. Well, there were a number of questions. I'm going to start off with my first question, and then I'll get to some audience questions. But I was really struck by your discussion of lapsed internal regulation and how that may serve as the rationale for external regulation.
Exactly.
But I'm curious if you think that the motivation for regulation of healthcare has changed in nature, and whether you think some of these laws that you talked about that are really impacting provider practice, like the Tennessee Medical Ethics Defense Act, is truly an effort at resolving some lapsed internal regulation, or whether it's based on something else.
I I do not think that the degree of invasive pervasive policy impacting people's day-to-day lives and day-to-day medical practice um, justifies, like a course correction that's claimed to be needed based on this lapse internal regulation type stuff. I think that we really, kind of as a discipline, need to be very honest and humble about the areas in which we have gotten it wrong. But we also need to signpost all of those so that we can say, hey, the things that you're actually invading deeply into are not the things that we have been bad at in the past, like they're just not related. And that's why I think these historical inventories are so important. Because, as I go deeper and deeper into this topic and I start pulling out all of these examples, I'm just creating these like lists of things that, like, we're not doing what you say we're doing. And I just think that's so, so important. But it doesn't really help for the medical community to overexert kind of like that concept of expertise, and claim it as a mantle. I really think that we need to center kind of patient advocacy in all of these conversations, and show deference, or else we're not really going to be an attractive source of support.
Agreed. Interesting question from the audience. It's long. I'm going to read it to you though, because I think the premise of the question is important. But with regard to regulation, many of the areas where medicine got it wrong were fairly clear violation of rights,
Right.
meaning there was coercion or even deception. But the government, the attempts at government bans now are on areas where there is purposeful respect for autonomy, and there is a purposeful subjective designation of harm divorced from shared decision making inherent in healthcare. How do you view this in terms of respect for autonomy and liberty?
Um, I mean, I think that um, we are not as expressive and emphatic about the models of care that really embody respect for persons and centering of autonomy as we should be. I think that, the example of youth gender care, even though it has been described as, falsely described, I believe, as the subversion of autonomy and liberty, is actually just the opposite. Because there, to me, having practiced a range of different types of care in different types of settings, youth gender care is the most person and family centered, slowly paced, and flexible type of care that I can conceive of. It is very hard to help people understand that it is not a medicalized conveyor belt. It is not, raise a hand with a trans identity and receive X, Y, and Z as part of your care. There are many aspects of gender care, for instance, that if they were cross-applied, would, I think, really improve people's trust in medicine at large. Like in obstetrics, for instance, if we were so respectful and so centering of people's values and preferences and family structures, like I don't think that we would have as high a degree of, kind of like the terrible birth outcomes that we do in this country. So, I think that, the policies that regulate healthcare and the reality and how it's practiced and how it's described are kind of like dueling these days. And we're trying to assert ourselves as the people that should be trusted with internal regulation and with governing. But I think that that is not going to happen unless we do a better job at um, expressing how what ideal models of care are and why people should benefit from them. If that answers your question, I think the state is basically saying we can do it better. And we're not doing as good of a job saying why that's not true.
Right. You didn't specifically touch on this in your talk, but someone was asking if you could comment on how policy affects the payer pathway, how it's not just affecting provider patient, but the entire healthcare enterprise, which includes payers, and how that's impacting care.
Yeah, I mean, I think the biggest area that this is really scaring me is in the holding of hostage of entire healthcare institutions because of a single type of care that a place provides. So we're seeing this with youth gender care, but there's no reason why this can't happen with literally anything else that is politically disfavored over time. You know, the conditions for Medicaid participation, adhering to those is a financial lifeline for institutions. And if they are rewritten to write out certain types of care, whether that is, prescribing puberty blocking medications or gender affirming hormones for trans youth, or offering mifepristone or the COVID vaccine, or um, having a gestational age cutoff for neonatal resuscitation, like everything can come screeching to a halt. And I think that we are starting to come up against the consequences of having a system that can lord over everything if it wants to. Um, I don't have any good answers about how to deal with that, but what I can say is that we really need to see it that way and talk about it that way. Um, as we begin to conceive and imagine kind of better structures. But basically, my summary is the the way that the payer system is now, any type of care can be held hostage for any sort of reason. And we have a disinformation structure that makes that seem fairly palatable to the populace, and that's really scary.
So, interesting idea that someone was bringing up about the questioning whether we're reproducing institutional culture that trains providers to sort of, as they wrote, train, obey orders, and adhere to guidance and policies, which is creating now in this current environment a really challenging, situation, as you addressed, talking about professionalism and duty,
Right.
and how on the individual provider level we can all make changes. But are we talking about this as a culture of medicine issue in a sense of where personal moral beliefs are intervening in one's ability to deliver medicine,
Yeah.
either on a positive side or not so positive,
Right.
and whether this is sort of a questioning now of you're a person and a doctor, and where what gets checked at the door, and then how you really propose providers can act to their moral conscience.
Yeah. No, this is so important. And the reality is that institutions function like mini governments with mini doctrine and don't have the same oaths or professional duties that human beings in professional roles do. I think we feel that more than ever as, kind of the enforcement of policy shifts from the state to institutions and to clinicians, and then the state kind of is taking on this role of medical decision maker or like overlord practitioner. However, one thing that I think bears attention is that there is such a thing as, anti-discrimination health statutes that forbid, kind of the denial of care to people on the basis of identity or disability or any other, specific factor. Some states are really specific about those. There are patient abandonment policies that literally make it illegal to um, suddenly stop giving care to people. And I think that our policy architecture is now really at war with itself. And it is a very good idea to point that out all the time and to ask institutions over and over again, how am I not violating patient abandonment by not offering this care anymore? How am I, not violating a non-discrimination clause? What are you going to do to ensure that our policies don't conflict? So, I think hopefully we'll get to like some action discussion, but identifying those things in your networks is really, really important. It's something that I've been doing. It's something I've been talking about wherever I get the chance. And I think calling for more of those policies is also really important.
Thank you so much, Dr. McNamara, for this incredibly engaging talk. There are many requests for the presentation afterward. And so the location of the recording is in the presentation details document that should be in your chat. I wanted to just let everyone know about some upcoming events we have. Very timely next week, following Dr. McNamara, will be Dr. Mara Buckbinder talking about the impact of the Dobbs decision on moral distress among OBGYNs. My colleague, Jamie Connerman-Cease, will be presenting our Unpacking Bedside Bioethics series on December 2nd, talking about caring for patients without surrogates. And then in March, Dr. Casamano from the University of Minnesota will be talking about rural maternity care. And we will have more to update to the webinar list as we go. And then just a quick plug for spring courses through our Center for Bioethics. Our center director, Dr. DeBruin, will be teaching public health ethics. And I will be teaching pediatric ethics for any University of Minnesota students here or anyone interested in taking these courses or auditing them. There's a QR code listed here. Well, thank you again, Dr. McNamara. This was an excellent presentation. To all the attendees, thank you for coming and the really thoughtful questions. And the presentation details document will have both the opportunity to evaluate the presentation as well as to find the recording. So thank you to everyone for attending.